What's up, everybody, and welcome back in. We've got a hearing today in the Karen Read case where the Commonwealth tells the judge why they want and think they're entitled to Karen Read's parents' cell phone information and how they might use the public interviews that Karen Read is giving, and not just what she says, but what her lawyers say and do potentially during these interviews, which I found very fascinating as to the legal arguments they made as to why that information may infer certain things to the jury, or they may make certain inferences based on that. Very interesting. And they also make the point that just because the Commonwealth didn't use it in the last trial doesn't mean this new team won't use it in trial number 2. So we're going to watch this hearing together. We're going to answer your questions. Let's get into it. So I have pulled the majority of this hearing. We're going to skip a couple different points. We're going to skip the argument they make about whether service of process or the subpoena process was done appropriately, which state's law do you use. We're not really going to go through a lot of that. But we are going to focus a lot on the discovery motions and why the Commonwealth is seeking this information, whether we think they should get it or not, how they might use it, how I would use it if I was prosecuting the case, defending the case, things like that. We're going to talk through that when they discuss the information that they're trying to gather. But the first motion, which I thought was interesting, was the Pro Hoc Vice motion, which is just basically to allow a lawyer from another state to practice in your state. And as long as you file the right paperwork, pay the dues, have a lawyer in good standing in that state sign off on you, it's usually a formality. I haven't seen a lot of these even challenged. But in this case, it seems like David Yannetti felt like he had to make an argument to the judge that Robert Lassie, I think is his name, is the best trial lawyer. He specializes in this type of case. He should absolutely be allowed to be on this team. And the judge is like, okay, I'll take it under advisement. And she's going to make a decision as to whether or not to admit him to practice Pro Hoc Vice, which is just on an individual basis, right? Just to handle this case. We can't just go around practicing in whatever state we want. Now, there are some circumstances you can. Obviously, if you're barred in multiple states, you can practice in those states, no problem. You can handle a case easily. If you have reciprocity, meaning the bar that you pass in your state is also good to allow you to practice in this state, then you're allowed to do it through some easier processes. You've got to take CLEs, things like that, right? You can sign in on certain states. If you've been a lawyer long enough, you can be barred in certain states or federal jurisdictions. So there's lots of different ways to do it. But if you're just a lawyer from one state trying to practice on a limited basis in another state, you file a Pro Hoc Vice motion, and I've never seen one denied, to be honest. I've seen lawyers get kicked out or say, no, you can't do it because of how they act in that state potentially. And if you remember back when we had the discussion with Bob from Defense Diaries, and he was saying how, you can go in there and muck it up a little bit more in a jurisdiction you don't usually practice in. It's always got to tread lightly with that, right? Because that can backfire, number one. Number two, you can get the person into trouble that signed in for you, that said, yeah, this is a member of good standing. They're going to follow the rules, all good. They're kind of putting their reputation on the line for you as well. But in this situation, it doesn't seem like it's a rubber stamp. It seems like the defense has to prove it or argue or try to force the judge to allow it, which I find weird. I expect that that'll get granted, and this lawyer will be able to practice on a limited basis for Karen Read's case. Then we get into the discovery motions, and we're going to hear the Commonwealth argue first why they feel like they should get Karen Read's parents' phones, why they're relevant, why they're necessary at this point. And again, just because you're getting it in discovery does not mean it must be admissible for trial. Two different arguments. We're going to listen to the discovery argument here today by Mr. Brennan, special prosecutor.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In the second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. when Miss Reed knew that she struck John O'Keefe is the critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She called both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind.
So there's the big major nugget right there. They think that if they can get into the fact that she called her parents at 1:30 at night, right after allegedly striking John O'Keefe, that the jury would be able to know that a 40-something-year-old woman who would call her elderly parents at night would only do so if she had done something horrible, would only do so in dire, extreme, emergent circumstances, and therefore she must have done this. And she must have hit John O'Keefe, and she must have known, because that's the really important fact. For the second-degree charge, they must prove she knew. And they believe that these phone calls will help them prove that. A couple things. My initial thoughts when I hear that, right? Because you never know exactly how the state's going to use something, and now we hear and we know. Number one, I would want to know what the pattern is. Does she call them a lot late at night? Does she never call them late at night? How do we establish that pattern? How do we prove it? They're going to talk about that in a second. That's number one. Number two, why do you need Karen Reed's parents' cell phones to prove that? They already have Karen Reed's cell phone. They already know she made that call. You can make that inference without the parent's cell phone because we're balancing a privacy issue. Are we going to invade witnesses, the privacy of witnesses or family members of people accused of crimes? We know the rights of a criminally accused, but witnesses, family members, friends, whatever it may be, you don't just have the same authority to go take whatever you want from them or dig into their private life. So we have to balance their privacy. So why do you need their phone if you can get the information? If that's the reason it's relevant, you can make that argument just with Karen Reed's phone information. So why do you need your parents? That's another issue I have. Then we look at the fact that we don't know what exactly happened on that call. So how do you find out? Well, if Karen Reed doesn't take the stand, you can call her dad. You can call her mom. Ask them. Absolutely appropriate. If you want to call them, if you want to ask them those questions, if you want to put them on the stand as a witness, they are a witness to what she said that day. But you have to take what they say. You put them on the stand, you put them under oath. They tell you what she said, and you're stuck with that answer because nobody else can really prove what happened on that phone call. So if they say she was just pissed at John because, he went over his friend's house and he was drunk again or something like that, that may be helpful to Karen Reed's case, and Karen Reed's team may use that. And they may let the prosecutor call them so they can use a prosecution witness, Karen Reed's family, to say exactly what she did fits into their storyline. Mo said, just say it was a butt dial. Hey, yeah, it is kind of rich for the prosecution to argue that a phone call being dialed and answered proves something as severe as she knew she hit him, especially when, they're saying on their side it proves nothing. So that's what's really interesting about this whole process is we don't know what was said. We don't know who picked up the phone. I do think it's potentially relevant for them to have conversations and discuss what Karen Reed was doing and saying after the accident. I think that's very relevant. I think the Commonwealth has every right to get into it. But do they need the dad's cell phone information to do that? Because what else are they going to find there? That's not relevant, but might be embarrassing, or just invading someone's privacy in this situation is not something the courts usually want to do. So if they can make this argument, which it's a fine argument, if you want to make it to the jury and the jury believes it, fine. I don't find it overwhelmingly dispositive that this means she did something wrong because she called her parents late at night just because she's 40-something. I've got 40-something-year-old sisters that I think call my parents all the time, talk to my parents, every single day, all the time. I know my wife does. It would not be unusual for my wife to call her mom, late at night. But from my perspective, I think the argument is one that they can make at trial. I just don't know why they would need the dad's phone or the mom's phone to make that argument.
30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there were no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. There were 2 search warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided.
Just FYI, the judge's mic is not super loud, but I'll tell you what she said. She said the search warrants were not super clear, so that needs to be made more clear for her. But they're not asking for all the text messages, all of his Google searches. I don't think they're really asking for the call logs. And he's going to explain why it's just the call logs. And I think it's smart for the Commonwealth to limit what they're asking for, because if you ask for everything, a full download of the cell phone, it's going to be a hard no. That's way too much evasion of privacy. But if you just ask for a call log, that's something that is a lot more common in these cases, criminally and civilly. Were you making a call? Were you text messaging people? What were you doing? Were you awake? Did she call you out of the dead of night when you were asleep? Because if we can show that you didn't make any phone calls past 10 o'clock at night ever, because that's always when you went to bed, then she would know you went to bed at 10 o'clock and woke you up at 1:30. Well, then you can start going down we're going to make the argument that she called you because something really bad happened. Cleanse and Fire said she's drunk. Drunk people call everyone. That's a potential argument as well. Gail Taylor said, Peter, if they call Karen Reed's parents to testify, it will be so they remove her support. It'll be so they remove her support. If they call Karen, I don't know what you mean. Remove her support. I think that if they did testify, there could be some good stuff for Karen Reed. There could be some bad stuff for Karen Reed. I don't know, because they weren't called in the first trial. And we're going to get to the fact that I have still never watched any of Karen Reed's public interviews. And I haven't done that for a very specific reason. And I'm glad that I haven't, to have this conversation here today that we need to have.
By the defense, I can provide clear copies. The 2 search warrants from Ms. Reed's phone are from a period of January 28, 6 p.m. to January.
They can't be in the courtroom. You meant they'd have to be sequestered. That's what you meant. Okay. So there are arguments that they should still be allowed in the courtroom. There are arguments that they shouldn't be. There are arguments as to when they call them. Can you block them from the entire case after they weren't called the first time? So there's all sorts of different strategic moves that can be made for lawyers. And yeah, that might be one. So she doesn't have their support in the courtroom. Absolutely. But then if you don't call them, then you have some other issues that you can bring up with the court. Were they being honest? Things like that.
29th at 6 p.m.
Okay.
And the other one is January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Ms. Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Ms. Reed and her parents for 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an
I got to be honest with you. I know people are probably going to say they don't like this prosecutor and whatever. I think that's about as reasonable of I'm still not sure I would give it if I was the judge, and we'll talk about it after Ms. Little makes her argument, but this is as reasonably tailored and specific as you can possibly make it to prove what you want to prove. He wants it for 30 days. Why does he want it for 30 days? Because it's a limited enough period of time that it's not going to be expansive or overbroad or, invade his privacy any more than is necessary. That's number one. Number two, he wants it for 30 days because he wants to prove she doesn't call her dad at 1:30. She doesn't call her mom at 1:30. It's proving a habit. If it was something that happens all the time, he would want to know it, because then maybe he's wrong. I feel like he's opening up the fact that we're doing discovery. And if discovery tells me I'm wrong, I'm not going to make that argument. That's what I see from him so far, honestly. So he said he wants it for 30 days. Then he even says, if the defense says 4 months ago she called him every night at 1:30, he's like, let's expand it if they want to. If they want to expand it for 6 months or whatever it is, I'm agreeable. Because if it wasn't remarkable that she calls her parents at 1:30, I want to know that. Maybe it wasn't remarkable, but I think it was. And let's already remember here, he has Karen Reed's phone. So he's probably already done the search to see if she calls them over the last 30 days, however many times. So he probably already knows this. But I think it's very reasonable to prove this. I still am not sure why he needs the dad's phone to prove it, why he can't just prove it with Karen Reed's phone. But I think the argument tracks and it makes sense. And he's even saying, if they can prove to me that it is something that's a normal occurrence, that's fine, and we'll move on. Siobhan said, old people wake up in the middle of the night. I called my mom at 4:30 a week ago. She's not even old. I couldn't sleep and wanted to chat. But here's the point. I think what Brendan would say is you have a specific reason. You can remember that one night you called your mom at 4:30. If you happen to be accused of ending somebody's life that night, you happen to call your mom at 1:30, it may look suspect. It may not be suspect, but it may look suspect, right? And that's the point. And that's what Brendan is saying. If this is the only time she's ever called her dad at 1:30, we think there's a reason for that. We want to make that argument. And this could be in conjunction with some of the arguments they're going to make later about the interviews.
But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in.
So they're going to present witnesses that say if she called her dad at 1:30 knowing she hit him and didn't do anything to help him, they're going to have a medical expert to say she could have saved him his life right there at 1:30. So even if she didn't mean to hit him, even if she wasn't sure when she knowingly left him there and did not render aid, did not call 911, boom, that's intent to end his life or actions that were likely to end his life.
The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning.
Sorry, somebody asked why he calls him the government, and I think it was Betterow when I had him on the podcast said he thinks that's because he's used to doing federal work and it's wrong to call the Commonwealth the government. I think that's different in every jurisdiction. From my perspective, the state is also the state government. The feds are also the federal government. It's all the government, in my opinion. Prosecutors are the government. They are the state. They are the big bad government coming after you, poor citizen. And so, I mean, it doesn't bother me that he calls them the government, but some lawyers it does bother. The state, usually the feds in a federal case, the U.S. Attorney's Office, the FBI, you'd call them the government, but it doesn't bother me to call the state or the Commonwealth the government because they are a lower level of government. They're still the government.
And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial.
So now they're starting to weave in the interviews. And this is where the interviews are going to become very important. And I cannot believe or understand how Lally did not use the interviews. If there was anything incriminating in them in the first trial, it makes absolutely no sense to me. I would assume he watched and listened to them, but it makes absolutely no sense to me if there really were incriminating statements. Well, he's saying, we want that phone call to prove it with dad's phone. Then we're going to use dad's interview where he inferred or implied that Karen Reed hit John O'Keefe or thought she hit John O'Keefe. Now, is that true? I don't know. I haven't watched the interviews, right? But if he's saying it's true, it better sound like that. It better not be something ambiguous that doesn't actually mean that, or he's losing credibility. And once you start to lose credibility as a prosecutor, it's over from my perspective.
The time of the phone calls to Ms. Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation.
I don't love the words implied confession. I don't love those words. That seems a little vague for me.
And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24 hours.
So that's an okay argument. It's like he can say, no, she didn't call me, and he can denounce her records. He can denounce his too. It's better to have his and say, here are your records. But if your daughter's records show your phone number that you agree is your phone number that she called, denouncing those looks just as dumb in front of a jury as if he was going to denounce his own. So again, I like the argument. It's another argument as to why you need him. I just don't think it wins. I don't really think you need his phone records to prove what it is you're saying you want to prove. Peter, are you planning to do a best, worst, judge, prosecutor, defense lawyer again? Loved it. Maybe. We do those on some of the members only lives. We'll see. Sonia said, Peter, he speaks as if she's guilty already. Here's what I'll say. The prosecutor speaks as if he believes she is guilty based on the evidence he knows and sees. He does not speak as if she's legally guilty. He absolutely does not. He's mentioned multiple times she's the accused, she's presumed innocent. We're going to make sure we don't trample on her rights. He said stuff like that. But he should believe she's guilty or he should not prosecute the case. Based on the evidence he's reviewed, he should believe she is guilty as the prosecutor. Yeah, but then later it came out he was actually asking for a lot more than he just said, not just the call logs. So we're going to listen to Miss Little's argument as well and see if he overreaches and see if we think it should be limited, if at all, if it gets granted here.
Period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so
why would Lally not put that in if she admits that she struck something? I don't get it.
We cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting for records, and so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I know
so he may have asked for more in the motion, but what he's asking for today is pretty limited. And what he's saying there is some stuff could have been redacted from Miss Reed, Karen Reed's phone, because the team that removes any confidential or privileged information, it's like, so who cares if they remove that? It's not going to be on her dad's phone, obviously.
The defense point of collateral information, I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor. Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022.
So that is much more than just the call log, especially the SMS information. That's text messages. From my perspective, if I was her, my first argument would have been the defense or the Commonwealth has just waived asking for all of that with what they're telling you. They specifically said they just want call records, and just for Ms. Reed, they don't even want to see anybody else's numbers. So this is just call records from Ms. Reed.
And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022.
Yeah, no way. That's all way too much.
Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy.
Did you catch that? They're asking the court to sanction the Commonwealth for even trying to invade Miss Reed's dad's privacy. Number one, I don't think that would happen in a normal case. First off, I don't think they would sanction. I think that's a little bit too far of a reach from the defense, but it ain't happening in this case. I'll tell you that right now. Judge Cannoni is not going to sanction the Commonwealth for this.
So the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period.
So the judge cannot grant what he did not orally argue. There's no way she can grant his motion when he said orally in open court that he's not even seeking that stuff. So we can just assume, throw all that other stuff out. And really the only question in front of the court is the call records for 30 days specifically relating to Miss Reed, which again, I think I would deny because I don't know why he can't just use Miss Reed's phone. He did not convince me, I should say.
William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's.
See, but that's just, she's wrong because the judge is right, even though she didn't need to say it, especially like that. She's like, this is a new trial, Miss Little. It's like, all the judge needs to say is he could be a witness, right? Just like anybody else that talked to Miss Reed that day, that talked to Miss Reed about the motive in, Bermuda, they could be witnesses, or Aruba, wherever it was. Any of the cops, EMS, anybody at 30, any of those people could be witnesses potentially. So saying he's never been a witness is not really the best argument that they have. But I think she's trying to set up the fact that maybe they'll put them on the witness list to remove them from the courtroom, like you guys said, remove the support, then not call them anyways. Then maybe you ask for sanctions of some sort.
And he wasn't present at the waterfall on January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night.
The judge has already denied the defense's attempt at getting cell phone records from people that were actually on scene that night, which again, leads me to believe this motion is going to get denied. I think it should get denied personally. Will it get denied? I don't know. If it doesn't get denied, I would expect motions to reconsider from the defense for the cell phones that they wanted to get information from that were at 34 Fairview that the judge denied in the past. Probably on an invasion of privacy for that reason.
The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here.
And so she argues the Commonwealth did not even show those requirements. And additionally, they're arguing about which call was made when. Again, we're going to have some more timing issues potentially. But I think the Commonwealth might be basing a lot of this on the interviews, right? The public interviews that they did. Which again, that's the big question of this video is, are those coming back to backfire now that Brennan is here looking into them, digging into them, trying to use them in this trial in ways Lally did not?
Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning.
So here's the point. When two sides see things differently, one says the interview is saying she hit something. The other is saying either it didn't or it's saying she hit the Chevy Traverse. The other person saying we think she means she's hitting John O'Keefe. Usually what happens is we present that evidence to the jury. We argue what we think it shows. And the jury, being the fact finder, decides, was she admitting to hitting John O'Keefe or was she talking about hitting his car in the driveway? And that's up to a jury to decide. Not here in the public for them to spin it, whatever they want to spin it, because that's what we lawyers do, right? This usually gets presented to a jury. Why did Lally not present it to a jury? I can't get over that. That is what's made me think the interviews are a nothing burger all along. Because a prosecutor trying to convict somebody that has hours of them speaking, I would think at least parts of that would be used to prove inconsistencies, to prove lies, to prove she admits to hitting something. I just don't get it, and I have never gotten it. At this point, is there a tentative witness list? There could be. I don't know the deadline to file the witness list. My guess is they'll be on the witness list regardless, because you don't have to call everybody on the witness list. So if you're even thinking about calling somebody, you're going to put them on the witness list at this point. You don't have to call everybody. You put on a witness list. I don't know that to be the case, but I would guess they're going to be on the witness list, meaning Karen Reed's parents.
The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29th, 2022 is necessary to show that it would be unusual for Karen to have called her father. And
so it sounds like they really just want to get the dad's phone to see, is there a call at 1:30 on the dad's phone that's not there on Karen Reed's phone? Maybe something like that.
The Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed calls her father cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is
I can't help but wonder if his good faith basis for saying that is the interview, because if he's got phone records that show the call didn't happen, then that's pretty bad for him, right? And his expert testified you can see when things are deleted. Well, was a call deleted? Because they said other things were deleted in other cell phones, right? I don't know. It's kind of a fishy thing here, a little sus, as they say.
broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you. All right.
So then Brennan gets up and is like, that's our point. We don't know who she called. Did mom answer the phone? Did dad answer the phone? That's why they might be, witnesses. And of course, the judge is going to reserve ruling. No surprise there. Couple questions here. Cuzzy Farm said, watch Karen's mic drop outside the courthouse. We will talk about that. Debbie, why is this called a Rule 17 hearing? What's Rule 17? It's when they try to get discovery from a third party, the third party being Karen Reed's parents here for the most part. Plus, they're trying to get stuff from some of the media organizations. Paul K, I own an iPhone. How many pocket calls have you ever had? Well, the answer is a hard 0 for me. But I will say, my dad probably once a week. He refuses to hit the lock button, so he's constantly butt dialing me. Jilly May. Little is by far her weakest lawyer. I'd be so nervous to let her argue anything. She sounds like she's reading off a 9th grade essay. What I will say is she usually sticks to what is pre-prepared. And different lawyers have different skills. And I don't think she is bad at this. I think her voice kind of sounds nervous. I don't know that that means that she is nervous, but I think she does a good job with a lot of her arguments. And whether that's preparing them ahead of time or doing them off the cuff, I think that she has made some really good arguments throughout this process. Wafa, though out the first trial, I wondered why Dateline interviews were not used by the prosecution. I find them telling, but I'm not a lawyer. Love you, Peter. Happy Thanksgiving. Yeah. I mean, the fact that I have to assume that they weren't used because the prosecutors did not think they would be helpful to their case. That's really my only thought. Because if they were great, then I don't understand why the prosecutor wouldn't use them, right? That makes no sense to me. So then we get to the motion for reconsideration about talking about some of the information from the interviews from Karen Reed, the public interviews with the media. And we're going to listen to part of Brennan's argument now.
Are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly.
So we jumped kind of right in there, but what he just said was basically during these interviews, there are things redacted and cut out. We don't have the whole interviews. We need the whole interviews. We also want to be able to argue that her lawyers controlled this interview, controlled what she said, stopped the interviewer, changed course. Reed was changing her story after her lawyers would jump in. And we want to use that in the transcript to show her lawyers were constructing the story for the media, for the public, to try and push people her way. And then maybe we're going to get into witness intimidation. I don't know. But are they going to try to build this story against Karen Reed, her lawyers, the movement, the people on the outside putting pressure, trying to create this out of nothing? Is that what they're going to try to argue? That would be spicy, would be my guess. Now, he does have some pretty decent arguments that it's not privileged or confidential because there's a third-party interviewer in the room. So if Karen Reed and her lawyers are having open conversation or changing things or talking about what she's going to say, that's no longer privileged because there is a person in the room that is not an attorney and not a client.
On the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of a defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly there may be discussions in those redactions that involve her attorneys and Ms. Voss, but none of that is protected. None of that is protected. The defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril.
Even though he may believe she's innocent, he says she is presumed innocent.
They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way.
Now, if the microphone picked up private conversation between her and her lawyers, that would be confidential. That should be redacted. That should not come in. I don't necessarily know exactly the context of how all this came in. Ms. Saunders said, judge ruled new lawyers allowed. See Ted Daniels. Okay, that makes perfect sense. I would have been shocked if he was not. So that makes sense. Sonia, Peter, can a jury make a judgment on inferences? I hear this a lot. So the jury's allowed to make decisions based on evidence or reasonable inferences from the evidence. Now, define reasonable. Everybody defines that maybe a little bit different, but it's an objective person standard. If objectively reasonable people could infer something from a fact or from a piece of evidence, the jury is allowed to do that to make their decision. Yes.
If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall.
So he's saying if he put the reporter on the stand and there's a part in the interview where she starts talking about sipping alcohol, then we hear her lawyers say something, then she changes her story and it goes in a completely different direction. He wants to be able to ask, what was that conversation? What did she say to her lawyers? What did her lawyers say to her? And while it really, gives me, chills and makes me feel horrible, makes the hair stand up on the back of my head to think that you're going to ask somebody about a conversation between a client and a lawyer. If they're doing that in front of the interviewer, in front of the reporter, it's not privileged. It's not a confidential conversation. I don't know the answer. I don't know the context, but if it's true, it's a good point.
And it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about is just wishful thinking. That's all it is. And, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all three of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position.
So what does he mean by that? He said, we don't want to delay the trial. We don't want to lay the hammer on the defense team. We don't want to put them in a bad position. Well, what he means is if the defense attorney then is going to be called as a witness to say Karen Reed admitted she did it and confessed in front of a third party, making it not confidential, well, now you're an adverse witness to your client. And that's an unwaivable conflict, and therefore you can't represent her anymore. So we're really treading into some dangerous waters if we go this far. And that's actually what happened, of course. Is that what they're going to say? I highly doubt it. But theoretically speaking, he's like, we could be going into these waters. And that's not what we're trying to do, although it is possible. Martha said, wouldn't that be hearsay? So that's an exception to hearsay because the statements of a party opponent, which for the Commonwealth would be the defendant, a defendant's statements are admissible. Doesn't matter if somebody else says it. It's an exception to hearsay. The defendant's statements come in. That's why it's so dangerous anytime a defendant makes a statement.
They're all witnesses to a substantive statement. Many of them admissions of guilt, contradictions, all of them. And the most respectful way to pursue those, the strongest way, the fairest way to pursue those with moderation is to get them from Emily Voss in the interview that exists.
So he's saying instead of doing that, instead of wrapping the attorneys into this, we're just going to ask the interviewer and see what she says. Joanne said, Peter, the reason she called her mom likely is because she couldn't figure out where John was and she was worried sick. Guess what, Joanne? That might very well be true. But the point is, we don't know those answers. And the Commonwealth is just saying, we want to ask those questions. We want to know the timing of the calls, and we want to ask her parents, what was that call about? And they very well may say this, just like you said. And if they do, that's the answer. That's evidence. That's before the jury. The jury's going to consider that. But they have these interviews, right? They have statements made by the parents. They have statements made by Karen Reed. Are they going to be consistent? Are they going to be inconsistent? Is she going to say she was worried sick about John on the stand? But then in an interview, they said Karen Reed was, just butt dialing me or drunk dialing me. I don't know. But when you make all these statements, keeping everything straight is very important. He already said, vague confessions or whatever it was and implied confessions and inconsistencies. That's what he's hoping to find and use from these interviews is the inconsistencies, are the inconsistencies.
Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation, those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it. She said it. There's a difference. And Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that never even may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this.
There it is. He just comes out and says it. Part of their argument's going to be the defense was selling a story. The defense was trying to influence a jury pool in the public potentially. So this is showing us that could be a very different strategy, a very different line of thinking, very different arguments, way more aggressive and offensive this time around than last time, which felt like they were on their heels defending the McCabe's and the Alberts.
Continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself. The argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in the case. And my empathy is to Ms. Voss, but to every other witness in this case. She's in no different position. It does not impede the progress of the Commonwealth. It does not.
I agree with him there. There should not be intimidation. There should not be nastiness. There shouldn't be physical threats. There shouldn't be outbursts, stalking people, harassing people. That should not be happening simply because they're a witness in the case, and it shouldn't be happening to Ms. Voss. But what he's saying is, if I got to call her as a witness, I still got to call her as a witness. We have protections in place. We've got laws in place. We've got law enforcement in place. But if she is a witness, I have to call her. And that goes both ways. That goes for every single witness in person and lawyer in this case. It really does. Thank you, Netwoman, for gifting 10 memberships.
Impede the fact finding.
Actually, I think we're good with that argument. We're going to jump to the defense's response here. And he starts out with, we won this already, Judge. And if you have won it already, it's always good to start with that because this is a motion for reconsideration because they've won this similar motion in the past.
Original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion.
So it's like frozen right here on the video. So we'll just have to deal with the weird picture of them shaking. But one of the things he starts with is they didn't even ask for this stuff before, Judge. They weren't even asking about what the lawyers said. They weren't even asking about potentially private confidential conversations because it's inappropriate. They knew it was inappropriate. Well, guess what? That's kind of the point of a new prosecution team, that just because the old guys didn't do it, just because the prior team didn't do it, doesn't mean this team can't. And we're noticing right here, right now in this hearing, things are being done very differently. Round two. We thought it was coming and it is officially here. This is going to be a different fight. And just because the prior team didn't ask for it doesn't mean it's not relevant. Doesn't mean somebody else can't ask for it.
Now it's somebody changing the rules and says, oops, we've decided we want those after all. And
Didn't I leave that,
There's nothing inappropriate about that, right?
changing the rules and says, oops, we've decided we want those after all. And
didn't I leave that open for them though? Didn't I leave that open for them to come back even at the first trial? To come back and request it upon review of the first?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different?
She's like, we got new attorneys on both sides. I left it open and now they're asking for it. So what's the problem? Where is Karen Reed's main attorney? So he's appearing via Zoom. I don't think he could get back in time for this hearing. Mr. Jackson.
Different than now.
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
I just don't think that's a good argument. I just don't think that's a new argument. Peter, didn't you say you couldn't bring in, didn't you say in a new trial you can't bring in new evidence? So this is all already known, right? You can bring in new evidence if it is relevant, but what you can't do is create new evidence, right? But if there's new evidence that can be found or can be discovered, you can absolutely bring it in the second trial. Absolutely. Now, they wouldn't have been able to bring this in if there was an appeal, right? If there's a mistrial, it's basically we start over, we go. And if the judge opens discovery, so there's another reason. I have had mistrials before where the judge does not reopen discovery. I've had continuances before where the judge does not reopen discovery. And if the judge does not reopen discovery, then there's not going to be anything new that comes in. But if they allow for more discovery, and there is, in the interest of justice, the reason that they need to bring something else in like this, which they knew existed, the judge didn't allow it before, and now they make a new argument as to why they need it in, that's up to the judge and the judicial discretion. So it is possible for new things to come in, but I wouldn't call this new, right? Everybody already knew about this. The Commonwealth just decided not to use it. Same thing with Reed's parents. They would be new witnesses, but they're not really new. People are asking who this guy is. It's another defense attorney. And then there's even another defense attorney making an argument on the next motion.
Ways.
Okay, go ahead.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial.
I disagree. If she is contradicting herself within one interview, that absolutely is admissible impeachment to her credibility, and that she's changing her story and it's not making sense. And why is she changing her story? Why is she saying the things that she's saying? And the Commonwealth can make arguments on that.
And one has to wonder whether this motion is really...
this is Gretchen Voss's attorney. I didn't even notice that. That's my bad. This is Gretchen Voss's attorney. All right, my B. Not one of Karen Reed's lawyers. This is Gretchen Voss's lawyer.
An effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she will be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative and theoretical. You said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what did you?
So again, this wasn't the best argument, but they did win it before. So once you've won something like that, better chance of you winning again. We'll see if the judge allows any of that under these new circumstances. Some of this is tough to really answer and break down because I haven't watched the interviews. Okay. But I'm glad I haven't watched the interviews because if and until they present it to the jury, I don't want to consider it. Because everybody else that's watching the interviews and basing their decision or something off the interview, which I know a lot more than the jury does now because we followed between trial 1 and trial 2. But if you're basing something off that interview and the jury doesn't see the interview, it's not a fair comparison to what the jury is considering and hearing and seeing. Now, if the interview comes in, the parts that come in are going to be very relevant and we are going to break them down and talk about them. Thank you so much, Chris, for gifting these memberships. All right. Then we'll get to more arguments from the state.
This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains...
So he's saying one of the things the defendant's motion is they only want more audio because nothing in the current recordings are damaging to Miss Reed. And he's like, no. We disagree with that.
Damaging omissions by Reed. The audio provided thus far contains many damaging omissions to Reed.
The audio they currently have has many damaging statements to Miss Reed. Whether or not that's true, I don't really care at this point. What I do care about is this is a prosecutor who has now reviewed this case, potentially might be going to trial in just a little over a month or maybe 4 months, says there are absolutely damaging statements in the interviews. So if he believes that, whether or not it's true, if he believes that, that means Lally completely dropped the ball in trial 1. And I'm not saying that as Peter Dragos, right? I'm saying that as this guy, Hank Brennan, is saying severely or multiple damaging statements in that audio, and Lally didn't use any of it. This would also make me think he's going to use it in trial, right? You would think if there are damaging statements, he's going to use it. This was kind of a shocker to me that he just went flat out and said it, because now that he said it, you better use it. Like if you want justice for the victim, right? And you're the community and you're the victim's family, John O'Keefe's family, and he's saying there are damaging statements, why are you not using those damaging statements? It makes me think, and it makes the public think, right? Rightfully so, that we don't believe you if you don't use them. We don't believe you. So if you think they're damaging, you better use them, and the jury's going to make the decision.
In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews, the story changes. At one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions...
Okay, that's an example of an inconsistency. How damaging is that statement? And are we back with Lally in that maybe that was more confusing than proving something? Was Lally actually right? Is there more? Is it just between the statements of the side door and the front door? What's considered the side door? There was so much talk about how the house was laid out, what doors were where. What does she consider the side of the house, the front of the house? How messy does that get? Is that the damaging statement? I don't know. I don't know if there's more. I don't know if he was just giving one example. Jojo said, how did they bring the statements in? Like through the interviewer? Statement to the defendant, they can get in a million different ways. If they can authenticate that it was in fact the defendant, which yeah, with the interviewer, that'd be one way. I sat down, I interviewed Karen Reed, okay? And here's what she said, and you play the interview.
given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so...
and then That to me, and again, if I'm thinking like a prosecutor, and he's almost got a little smirk on his face when he says this, she gives multiple interviews, right? And so if I'm presenting a case with a timeline and I'm trying to make Miss Reed's statements, the inconsistencies be important and purposeful, she did it for a reason. She's trying to pitch a story. She's trying to mislead the public, right? If that's what he's trying to do, then this is how you present it. So here's her story at first. Then the Commonwealth produces discovery to the defense. And we have a certain fact in there that it was the front door, whatever it may be. Then here's interview number 2. Guess what? The side door now changed to the front door after she got this information. But then guess what? There's more. We produced discovery that says, this was his time of death. And she gets interviewed a third time. And now the time changed that she left the Fairview residence. Why did it change? Well, she got this discovery. I'm just making that up. I don't know that that's actually how it works out. But sometimes you can lay it out like that. And that's why think about all the cases we've talked about when the defendant makes statements. Even Alec Baldwin, I think, would have presented like this if the state wouldn't have completely fumbled the case away and blown it. They would have used his interview, the inconsistencies, what he said, what he was adamant about, what he said he knew and didn't know, what he was right or wrong about, and when he was right and wrong about it. That can be incredible. She does not have to say, I hit John O'Keefe in the interview for the interview to be relevant. She does not have to say, I hit John O'Keefe for them to be able to use parts of that interview. But if there are subtle changes and the timing of those subtle changes come after a lawyer objects and after we've presented her with discovery that prove a certain fact, I'll tell you right now, I know you guys in the chat. And I know if stuff like that starts happening, you start giving the side eye to the defendant. And if you start thinking the defendant's lying, well, now it becomes a lot easier to prove a case and convict the defendant. It happens a lot. I'm not saying that's what's going to happen in this case because I don't know what was said in the interviews. But if he's planning on using the interviews and he thinks that there are inconsistencies based on the timing of the lawyer's objections and them kind of changing the narrative and the discovery that's being presented by the Commonwealth that she, shouldn't know if she wasn't the person who did this, we'll see if he's able to do it.
I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position, that is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made, 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally in Ms. Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water.
So that's interesting because to me, okay, so change that fact. It doesn't really prove or disprove that she did what they accused her of, but does it make her look bad? Are they going to be able to use those interviews just to make her look bad? Is that going to be a strategy of the prosecution? Because, that to me, I don't know. Does that actually prove the necessary facts? Does that get over the huge humps and issues with the investigation and, the accident reconstruction? Does that get over any of those issues? No, but I think some people don't notice because they're pretty dug in. Most people that are watching this and are following this case are pretty dug in on whatever side they may be on. And I understand that. And it's hard to pull people out of the side they may already be on. But I think if you're a juror that doesn't know anything about this case and you start hearing things like, I was sipping, oh, actually it was water. And then you hear blood alcohol content. Now, even with he didn't get hit by a car potentially, she was back on his Wi-Fi at a certain point. Timeline doesn't, line up for the Commonwealth and all those major issues. But if you start to think you don't trust Karen Reed early in the Commonwealth's case and that she's lying to make herself look better or, trying to cover up what she did, potentially I think that can make her look worse earlier on and get her into the Commonwealth's camp. It's a dangerous proposition. I don't know if it'll work or not because there are still major issues with the case, but it's definitely better than asking everybody how much it was snowing. definitely a better strategy than that.
And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said it was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it's a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 of the affidavit. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to.
He's like, I can't speak for them at that point because it wasn't me. Then they start discussing whether or not they can, or they discuss some of the interviews of the family members. So let's talk about this. We've already kind of mentioned the interview with her dad a little bit and what the Commonwealth might try to use for that. So we're going to jump to that argument.
On subsection 5, some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at.
So we know the defense is going to say that's John's car. The Commonwealth's going to say that's John. Could be up to a jury to decide. Regardless, not an admission she committed the crime, but maybe statements they can try to use against her. And again, that's what lawyers are going to be looking at this stuff. What does this prove? What do we think this proves? How does this fit into our case? And when they discuss that, you may not agree, I may not agree, but the way a lawyer looks at it, what a lawyer can infer and argue and imply from certain facts, or what the jury's going to infer from certain arguments or facts the lawyer presents them with, is something we don't really know. So if they can use that, and by the way, I've talked to a lot of jurors on a lot of cases, and even people that think somebody's guilty or not guilty for whatever reason, and I will tell you, well, she admitted she struck something, sounds very familiar with why people make the decisions they do. Whether they say, clearly she struck the car, clearly she struck him and she admitted it, those kind of statements can get you across certain finish lines regardless of what side you're on. So they can be very important. Zom said, Peter, can the defense recall the same FBI experts on retrial, new jury on retrial, right? Would they know this evidence did not use in the first trial? So yes, they can recall them. It is a new jury. No, they would not know necessarily that this person wasn't called or was called in the first trial. There are certain instances where you can make arguments that, you weren't called the first time around. Sometimes judges would say that's not irrelevant. But usually they don't know what exactly happened the first trial. And to try and not tell them there was a first trial, we'll say in a prior proceeding, you testified like this as opposed to the prior trial. But I've also seen certain different jurisdictions do it differently. And some jurisdictions that said in the first trial, you testified like this. For the trials I've done or redone or had mistrials or close to mistrying them or trying them again after a trial, usually we say a prior proceeding or something of that effect. Karen spoke to the media at the stairs and said it's ridiculous that all these sources had her admissions and never used them. Ridiculous. Yes. She made some kind of comment and somebody referred to it earlier that, oh yeah, they had all my confessions and they've just been sitting on it all years. You would think they would print those stories because they would crush, right? If you say, I have her confession right here, that'd be a pretty great news story for them. I highly doubt it's any serious and real, locked and loaded confession of Karen Reed. But that doesn't mean that with a new lawyer, a skilled advocate like Hank Brennan, that there are not statements he thinks he can use to fit into the theory of his case. Netwoman, he put more emphasis on things that were said to the media rather than their great detective work with Solo Cup. Say, Netwoman, I think you and I can both agree that's a better strategy. Because if you really talk out and shine a light and put a microscope under their great detective work, that ain't going to go well for you if you're the Commonwealth, right? I think we can all agree on that.
The phone records that are available for Karen Reed, and seeing there was a phone conversation that morning to William Reed's phone that phone conversation is before Karen Reed is admitted to the hospital. And so it is by inference in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make, that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit, supposedly now, another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that would be the subject matter.
So he's saying the fact that they're talking about a collision at 1:30 in the morning or 6:30 in the morning or whenever it is, when she knows John O'Keefe's dead now at 6:30, why would they be frantically talking about her backing into his car? That doesn't make any sense. And again, do we agree with that? Do we disagree with that? Not the question before us today. What the Commonwealth is doing is laying out the implications and arguments that they can make based on the facts and the evidence. But how do they get that information? How do they present it? Seems like they've got to call the parents. But then you have to ask them what the conversation was about. And if they say something different about her running into something or striking something, then you need the interviews to be able to impeach them. But it definitely seems like they're going to use these statements that were made as purposeful statements to present a story to the media, to try and put the jury pool on their side and create this narrative publicly. But it got inconsistent when she was presented with the evidence through discovery. So she had to change her story, which she did multiple times through these interviews. And they're not going to say it, but she was fine to go on all these interviews and talk to 2020 and ABC and, whatever, but she's not going to take the stand and talk to you. They're not going to say that. Of course, that'd be totally in violation of her constitutional rights, but will the jury think that? If you hear she's done all these interviews, but she won't get up and talk in front of you when her life's on the line, why? Because she's got to be under oath? Is she scared of being under oath and telling the truth? Some funny business or, outside character type of arguments that can be implied from some of what the prosecutors that are going to present and infer that I think might not be good for Karen Reed. Again, it doesn't deal with the issues like the red Solo cups and the investigation and the accident reconstructionists. Yeah, happily ever Beachy said maybe she'll testify this time around. Maybe she'll have to. Seemed like she was ready last time, but they thought it was going well for them, so she didn't. I find this motion hearing incredibly revealing about what this next trial is going to be like.
It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter.
It's clear that those are arguments he's going to make, that the Commonwealth's going to make.
And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all the statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context. Some of the doctrine of completeness. We should know what the entirety of the conversation interview was so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked
Very likely will be a witness at trial
about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or cooperation, that both sides are aware and know of the substance of that material. And that is the
Interesting. Really interesting to see how different this is, because none of this stuff came in the first trial. All right, we're going to jump to the telematics argument.
And I need to see how we progress with it. The Commonwealth's notice regarding the testing of the telematics system, where do we stand with that? Mr. Brennan? I know you had said you told them that, Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did. And if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they're going to
State expert, defense expert together heading to Texas on December 2nd to get this done. So it's happening pretty quickly.
test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts to December 5th.
Okay.
And they're going to do what's called the chip on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car, because there's different software which will give it even a more fulsome reading.
All right. So that's happening. Lastly, we are going to jump to the protective order about how the Commonwealth has already started turning over more discovery and giving some of these details and information to the defense team, but they want to block anybody that wasn't the lawyers that's able to see it. And Yannetti wants to argue against that a little bit. This is going to be the last clip. I got to run. We're already a little over time, but Yannetti's like, this makes no sense. It shouldn't be protected from certain people.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the...
That was the big thing. It's like, how are you not able to share this with your client? That makes no sense. Your interns or people that work for you, other attorneys. You can't just say like Yannetti and Jackson are the only ones that are allowed to see this, or just lawyers. It's like we use so many more people that aren't just lawyers to help us presenting a case, investigate a case, plan a case, prep a case, including the client. Sometimes most importantly, the client, because they know all the details of where they are and what they did and what happened. So to block it from the client was just wild. But based on the allegations they made before that, changed the story based on the discovery. But now it sounds like Brennan doesn't even have an objection to extending it, making that small circle of trust a little bit bigger.
Protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense team?
objection to the parties they'd like to share with, and I understand there's no prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone.
Could you imagine a defense lawyer? Because that's what Hank Brennan is. Don't get it twisted. He is a defense lawyer. Going through the DA's cell phones, personal and professional. My guess is he trusts Brennan, or he wouldn't have picked him to do this case, but yikes.
Obviously, the personal cell phone becomes relevant because he used a personal email address to make an ex parte communication with the court. One concern that we have is that
he said, obviously, his personal cell phone became relevant because he made an ex parte communication with the court on a personal email. That's from the Bettero letters that we broke down in a podcast with Mark Bettero.
Email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not emails, but text messages, apparently they're somehow remarkably set to auto delete after 30 days.
Excuse me? You have your text messages set to auto delete every 30 days as the DA. Now, that might be common for politicians. I don't really know. That seems wild to me, right? Like, I can't tell you how many times I go back and look at text messages that are more than 30 days old. Number one. Number two, when did he turn that setting on? Usually you can tell that. Number three, I have so many questions about this. So many questions about this. I would love to get this guy on the stand and talk to him about it. Why do you do that? When did you set it like that? Personally and professionally, question mark. Do you tell your, excuse me, do you tell your assistants to do that? Is that something you teach? And if so, why? And then I'd like to call Apple or Outlook or whoever would have this information. What percentage of people check that box to auto delete after 30 days? I would just love to know that. Might not be relevant. Is it 1% of phone users, of iPhone users, Samsung users, whatever it may be? It can't be a large percentage, right? To auto delete every 30 days. I mean, how sketchy does that sound? Now, what I will say is there are a lot of conspiracy theories and people thinking the government's following you and stuff like that. Usually not a prosecutor, a government prosecutor, but I can understand it, right? Clear your search history, clear all your text messages. I get it because you think people are following you or whatever, or listening to whatever you're doing. Okay. And if that was his reasoning, okay, I'd like to hear it from a government employee, from a politician, basically. I mean, that to me is wild. I think I have mine like after a year. And that's only for like the data stuff, because I have like 99 cents here or $2.99 here from Apple for all this extra storage. And I have too many group chats. Netwoman, I shouldn't admit this, but I've backed into my closed garage. Yet didn't damage my car at all. Thanks for doing overtime for us. Very grateful for you, Peter, John, and Kelsey. Yeah, I'm not going to share any stories of any of the women in my life and what they may or may not have backed into. But it happens. It happens. And unfortunately, you can damage not just one, but two cars that we own in one accident. All right, let's keep listening to him talk. I was shocked at this.
That obviously raises some questions for us. Maybe the subject of a future.
Diana said it's the default setting. No way. Maybe she made another comment earlier. There's no way 30 days is the default setting. No way. No way. I've had 10 iPhones. Never, ever has this happened.
Motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I
Are they
believe.
preserved, Mr. Brennan?
I've been preserving them since I started the past last week. I'll continue preserving them.
All right, so that,
Yes, that deals.
So he's worried. The judge is like, well, that's being preserved, right, Mr. Brennan? And I think he said yes. It's kind of hard to hear. It's kind of mumbled, but I think he said yes.
With that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan conducted himself. He had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
okay. The significance of that is,
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed R-E-E-D, which is how Mr. Morrissey typed it in his ex parte.
He's like, we need Reed the right way and the wrong way, just in case it was supposed to be hidden. And again, this comes from the Bettero letters.
Communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name. But
We don't know if he did it intentionally to bypass FOIA requests, anybody that's interested in the Reed case, the actual Reed case, or if it was just a typo. Obviously, one being more nefarious than the other.
believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court where this case originated and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication. And we'd ask that a more thorough search be done for these types of communications.
all right, so why don't you,
Shocker. They don't trust Mr. Morrissey. That's the least shocking thing we heard in this motion hearing. All right, I've got to run. Hit that like button, guys. Hit it. If you haven't hit it already, make sure you're subscribed. So much going on here. We're going to talk about this more. We'll talk about this more. I don't think this case is done, right? December 2nd, we got more stuff coming on with the experts going and downloading the data. We will continue to talk about this case. I appreciate you guys joining me so much. I do have to run because I have a 4 o'clock appointment. So hit the like button. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.